When does discipline become child abuse under Utah law? Most parents understand there's a difference between discipline and child abuse. The difficult part is figuring out where that line actually exists under Utah law, especially during divorce and child custody disputes. A recent Utah Court of Appeals case opinion in State v. Paramoure highlights how complicated this issue can become. Utah law does allow parents to use reasonable force in disciplining children. But the key word there is reasonable, and once outsiders become involved, like police, DCFS, therapists, guardians ad litem, custody evaluators, judges, commissioners, people often disagree sharply about what reasonable means. One parent may view a spanking as ordinary discipline. Another may view it as abusive. Context suddenly becomes critical. How old was the child? Was there injury? Was there anger involved? Was the discipline controlled or reactive? Were there marks or bruises? Those details matter enormously once the legal system enters the picture. And divorce magnifies everything. In intact families, many discipline disputes remain private. In child custody disputes in court, they often do not. A teenager texts the other parent. A bruise gets photographed. A school counselor makes a hotline report. A parent contacts police just to document things. Then suddenly what felt like an isolated parenting moment becomes a legal event. And once that machinery starts moving, it can become exceedingly difficult to stop. A single incident can trigger DCFS investigations, emergency custody motions, supervised parent time requests, therapy requirements, even arrest. Even when allegations are exaggerated or unsupported, the accusation itself can still reshape the entire trajectory of the case. That is one reason many experienced family law attorneys advise parents to avoid corporal punishment entirely during active litigation. Not necessarily because every form of physical discipline is illegal, it's not, but because the legal risk is often wildly disproportionate to whatever short-term benefit the parent believes the discipline provides. One important lesson from the Paramoure opinion is that even courts sometimes struggle to apply these laws correctly. The Utah Court of Appeals reversed the father's conviction, in this case, because the jury instructions improperly framed the legal analysis. Think about that. Even after a full criminal trial, the legal system still got the instructions wrong badly enough to require reversal. Parents need to understand what that means in practical terms. These cases are messy, emotional, fact-sensitive, and sometimes imperfectly handled. We also live in a world filled with smartphones, recordings, Ring doorbell cameras, and text messages. A moment of frustration that once might have remained private can now become permanent evidence. Sometimes misleading evidence. Sometimes devastatingly accurate evidence. Either way, it becomes evidence. So the better question for divorcing parents is usually not, can I legally get away with this? The better question is, even if I believe this is lawful, is it worth the risk to my relationship with my child and my position in court?